Good day to you all. My name is Elizabeth Msipa and I am a second year law student at Africa University. I have prepared a video to teach you guys more about what the law of delict is and what defenses apply to what cases. I hope you enjoy. Thank you. Hi everyone, welcome back to our podcast. My name is Elizabeth.
And mine is Michelle.
On today's episode of It's Your Right to Know the Law, we will define what a delict is and we will be taking scenarios from you guys.
Now, Elizabeth, I am not well versed with the law, so educate us. What is a delict?
A delict is a wrongful act that is done either to a person physically, emotionally, or psychologically, or even to your property. So the law of delict seeks to protect your interests by allowing you to sue when your interests have been damaged by someone else.
And what is a defense?
A defense is a strategy used by lawyers to help their legal clients to escape liability, and in this case, intellectual liability. So it could either be a complete defense whereby, as a client who has been sued, you have been exempted from paying any money, or it could be a mitigatory defense, meaning that you are only free from the liability to a certain extent, so the court will release you from paying the full amount to perhaps half.
Awesome stuff. Now that we know those definitions, let's begin. Our first listener is a mother, and she says, "My daughter went out one night without my permission and came back the following morning. I took it upon myself to discipline her by hitting her with the belt a couple of times. She later reported me to her aunt from her father's side, and her aunt thought I was wrong for doing that. If this were to go to court, who would be wrong?"
Well, according to the law and perhaps even socially, you are not wrong for chastising your daughter after she came home late. It is your duty to discipline your child. This is known as corporal punishment, and this is provided for in the law of Zimbabwe. So if this matter were to go to court, for you to be acquitted or found not guilty, you would rely on the defense of authority. The law in Zimbabwe says that one may escape intellectual liability, being sued, or even criminal liability if they have been authorized to act in the manner they did. If you could search up the Criminal Codification and Reform Act, Chapter 923, I'll repeat that, the Criminal Codification and Reform Act, Chapter 923, Section 240, it will show you the defense of authority is a complete defense. You are in a legal position to discipline your daughter.
So in what cases would it be wrong to beat up a child, or what is the limit?
Section 241 of the same act reads, "Where moderate corporal punishment is administered upon a minor person by a parent, guardian, or school teacher within the scope of that authority, the authority shall be a complete defense to a criminal charge alleging the commission of a crime of which the administration of the punishment is an essential element. The way you administer the discipline must be reasonable. You cannot call beating your child with a thick stick in the head discipline because there is a risk that may lead to her death. It would be illegal for your friend to beat up your daughter or for the headmaster to discipline her." I hope this response has enlightened you.
That makes a lot of sense, really. If we were to not discipline our kids, then who will? Our next listener says, "I was driving on the main road, and as I was overtaking, the car in front of me suddenly turned right, leading to a collision of both our cars. The matter is still yet to be resolved at the police station, but I intend to sue for damages of my car. I have not yet met with a lawyer, and I would like to know what are my chances of winning the case. So far, the police have told me that although the person in front of me was wrong, I was also wrong as I overtook where there was a solid white line. What response can we give this listener?"
In this case, unfortunately, the police are right. You are also to blame because you played a role in getting your car damaged. So the defense that the person you're trying to sue will rely on is contributory negligence. This means that since you contributed to harm caused by also being negligent, by overtaking where there's a solid white line, they will not be expected to pay the full damages you're seeking. They will only pay a certain amount which will be decided by the court. So if you'd like to understand the defense more, you could look at the Damages Apportionment and Assessment Act, Chapter 806, Section 4, Subsection 1. Damages Apportionment and Assessment Act, Chapter 806, Section 4, Subsection 1.
So you're saying in some cases both parties can be wrong?
Yes, they can.
All right. This listener says, "I own a transportation company, and while transporting mini meal for a client, a storm started and damaged the goods on the way to their destination. They have since demanded I pay the sum of the damaged goods as they did not make it to their destination. I would like to take this matter to court as he has been quite persistent. What defense can I take in this instance?
I would take it that in this case, the person did not ensure their mealie meals, so the defense that you can rely on is called inevitable accident. This means that the goods were damaged not because of your own negligence or intention, but by vis major, meaning an act of God. It was beyond your control to stop the storm and protect the goods. So in this case, you are not liable for the damaged goods. You must, however, prove to the court that the goods were damaged by a heavy storm for you to avoid liability.
Alright, our next listener says, I was taking a walk in my neighborhood when I came across a child screaming frantically as she was being chased by a dog. I then ran after the dog, throwing stones at it, and it eventually stopped chasing the child and died. The owner of the dog is trying to sue me. What advice can you give me on this matter?
First of all, I would like to commend you for protecting the child, and the defense you could rely on in this case is that of necessity. It means that your unlawful actions of harming someone else's dog were necessary in order for you to protect the child from getting hurt or injured by the dog. It is provided for in Section 263 of the Criminal Codification and Reform Act.
I do also commend this listener for protecting the child. I think in some cases we're forced to do things that are really out of our control.
Yes.
Our last listener says, I have recently undergone a surgery that has left me permanently injured. I am considering suing the doctor for medical negligence. Would I win that case?
If the doctor had clearly explained to you, the patient, the risks of performing the surgery and that there might be permanent disability, and you went on to sign an indemnity form or consent form, then you cannot sue the doctor as he cannot be held liable for that as he had explained the risk clearly. So there was consent or voluntary assumption of the risks from you. However, it is unfortunate that this happened to you.
Well, that's all the time we have for today. But before we sign off, Elizabeth, is there anything else you would like to add?
Yes, indeed. It is important for a person to take full accountability for their negligence. So in some cases, you can tell that you were in the wrong, and to avoid costs of the suit, the cost of having to pay lawyers, process papers, etc., it is better to admit to your negligence and settle the matter outside of court. That will save you a lot of money and time, which is why it is important for you to know the law.
Well, that's all the time we have for today. Hopefully, this episode has been informative and may assist you if you ever are in similar scenarios. We urge you to know the law as it is your right and download the Constitution so you familiarize yourself with these laws. Catch us on the next episode where we will discuss unconstitutionally obtained evidence in the law of evidence. Thank you so much for listening. Have a good day.
Goodbye.